Okay, we have both the parties. Mr. Jonas, you will need to unmute. You have. Thank you so much. Would you like to reserve any time for rebuttal, counsel?
Yes, Your Honor. 5 minutes, please, Your Honors.
I have got it down, and I will let you know when you arrive at that particular destination.
Yes,
You
good
may
morning,
proceed,
everyone.
counsel.
Yes, may it please the court, James Zonas, on behalf of the appellant, Mr. Garcia Rodriguez. Your Honor, what we have here, Your Honors, what we have here is a violation of probation, whereby a man in his middle 70s was sentenced to 10 years and his probation revoked by Judge Porter in Lee County. The basis and gravamen of the argument is that he was in a parking lot, and Your Honors have to appreciate it's a strip mall with dozens of shops, parking areas, and he was accompanying his wife to get a passport, which was also an office in that strip mall. There's a school apparently in this strip mall, and there's no identifying characteristics that would ever lend anyone to believe that this is actually a school. It's got a front door.
Well, in addition to all that, isn't it true that you could not see inside the building or inside the classroom from the parking lot during the daylight? And that was agreed to by the probation officer?
That is correct,
So
Your Honor.
the question is, you're talking about paragraph condition 32, which prohibits a probationer from visiting a school. And the definition of visiting is not provided. Does it mean going to the school, going to the outside of the school, going to the inside? Was there any testimony as to what visit means?
Yes, there's actually visiting. You could visit a school pursuant to his probation as long as you have permission from the probation officer. But he is clearly not visiting a school. We have a GP. Visiting in my definition would be actually going inside the school, which would be virtually impossible in that it's a Montessori school and it's labeled. The only thing that identifies it as a school is a taste of me. It's got one door entering the front. There is no playgrounds, and I'm sure to be certified by the state, they have to have it as a secure facility because.
Well, I'm trying to figure out why the state charged a violation for someone parking in a strip mall in a shared parking lot close to a school without showing he knew the school was there. He had some nefarious purpose. There was children outside. There was something connecting the prohibition against visiting a school with his location.
Yes,
Was that ever answered?
Yes, Your Honor. There is a GPS monitor that I guess activates, from what I'm gathering, and these coordinates were not entered into evidence, but it turns red if you're near an area. But Mr. Rodriguez.
Well, it was a 3.5 minute period of time.
Right. It's only
3.5 minutes that it turned red. But so back to my question. What was the state's case based on besides what you have explained?
Well, the main problem arrives at that they interviewed Mr. Rodriguez, said he wasn't credible. He had a driving log that had been finished to the bottom, but the Judge Porter had suggested he should have gone onto the back and finished out more of the driving log. The basis was that he was interviewed by a probation officer, a certified probation officer that spoke Spanish. This probation officer never attended the court proceedings in front of Judge Porter. They used his English-speaking probation officer.
But the state's going to argue that was unpreserved.
They would argue that, but it's double hearsay. And what would it hurt? The man's doing 10 years for this purported violation. They should have brought in the actual. It's double hearsay.
But if it's not preserved, that argument falls on deaf ears. We're not supposed to consider unpreserved error unless it's in connection with incompetency of counsel that is apparent on the face of the record. And that argument was, you didn't make that, not you per se, but the argument wasn't made. Counsel is incompetent, and you may not have to get there, but let's keep going.
Yes, I would agree that there's ways of taking all the facts that were on the record and finding that there's no willful intentional violation.
Willful and substantial, or substantial.
Or substantial, Your Honor. There's
Would
no
the driving log
willful.
come under that category? How do you classify the failure to maintain the driving log? I mean, there's a whole week. It looks pretty suspicious. He's allegedly, checking out the school, and that week he coincidentally doesn't maintain his log, and he hands in a log that stops the week before the episode.
Well, I would suggest, Your Honor, that he is filling out the driving log, and if Your Honor refers to the record, it says that he finished the driving log to the bottom, and Judge Porter suggested that, hey, you're supposed to still maintain, you can get another piece, you can go to the back, but this is a 76-year-old man of diminished capacity.
Well, I know, but let's try to use the standard review that we're stuck with. He was using a blank sheet of paper in the past. He wasn't maintaining a log other than on a blank piece of paper where he put the information down, right? And he never and he was told the night before he went, and he was told to bring it with him. And he was told to bring it on a day that was not his regularly scheduled day. And then he had diminished capacity. He had a psychotherapist testify, not necessarily as an expert, but gave testimony in the nature of an expert. So you've got other arguments, but if the judge throws that all out and says, hey, it's based upon credibility, I don't believe a word he said. I don't believe the psychotherapist. I believe nobody. I believe hearsay. I believe double hearsay. How do we get around the standard review? And you can convict on hearsay alone, but it usually has to be tethered with some other direct evidence of some sort. A driving log could be direct evidence.
That could be, Your Honor, the direct evidence, but the driving log is a ministerial at best. We have a GPS monitor on this defendant's leg. No one's denying that he was in that parking lot for 3.5 minutes, and I think his witnesses testified that he was there to pick up the wife's passport. It did sound like the wife was bringing him around town as an errand. He's a passenger in the car. They also suggested he didn't remember where he was 6 days earlier. But if the probation officers actually felt at risk of him harming children or being near children, they wouldn't have waited 6 days to pull him into the office.
Did the woman who was eating her lunch under a tree ever testify to Mr. Rodriguez asking for directions? She was somewhere under a tree outside the parking lot where he was parked for the 3.5 minutes and having her lunch. And he said, you know, where am I? Where's Waldo? How do I find the motor vehicles? There was something more going on. Did that lady ever testify that this actually happened?
There were no witnesses from the school or anyone outside of the family, and the probation officer that was not the probation officer that spoke with Mr. Rodriguez. And his testimony that he was looking for directions according to the Spanish-speaking probation officer, but it's an event 6 days earlier, and I would suggest that he can't remember accurately, and he may have no credibility about his testimony that he was asking for directions. It's a 3.5 minute stop at a passport office, and
there was no dispute that his wife was driving. He didn't drive himself to that mall.
He didn't. There was no other evidence. The wife testified that she was driving there for a passport. And
so let me ask you a question. If the wife is driving him, leaves him in a car nearby a Montessori school, how is that willful?
I would suggest that it's not willful outside of his red marker. And that's hearsay too. I don't know if it lit up, if the GPS signaled that he was near a school. And that might explain why they were only there for 3.5 minutes.
Listen, I've been peppering you, and I apologize, but I was concerned with some of your facts. But I'm gonna shut up and let someone else ask you some good questions.
Thank you, Your Honor.
Mr. Jonas, to determine whether or not the violation of the condition about visiting, the violation is not being near, on, or about a school location. So he's in a parking lot. There's a sidewalk that runs the area. That would be a common area for everyone to use the sidewalk, would it not?
That would be correct.
Right.
It is a strip mall.
Okay, so the term of art in this violation would be visiting, right?
That's correct.
Not being near, not being in the vicinity, or to be visiting. Was there any evidence from anyone that he knocked on the door of the school, that he sought entry?
I don't think there's any dispute.
Visiting is not defined by the statute, but as I understand certain arguments that we are allowed to do is we can look for the common dictionary meaning of visiting or visit. And according to one dictionary, visit means to go, to see, and spend time with someone. If that's what visiting means, I could not find any evidence in this record adduced by the state that he visited with anyone at that school or anyone affiliated with that school. Would that be correct based on the record we have before us?
Yes, Your Honor, that would be correct. And there was some testimony that his GPS moved around the parking area at 2 miles per hour. So he may have been looking for, or his wife may have been looking for a parking spot. But there was no testimony from anyone at the school or any complaint.
For the purpose of my next question, please allow me to ask you to make an assumption. Assume that the evidence is insufficient to sustain the violation of visiting a school. What happens if the court then concludes that the evidence was sufficient to sustain the trial court's ruling on the failure to have the driver's log? Do we remand it back to determine if the trial court would have still committed him to the care, custody, and control of the Department of Corrections based on that violation, or do we just merely affirm? What would you suggest that the court consider, assuming that hypothetical?
Assuming that hypothetically, we would ask that the court remand it, if not reverse the revocation. And the reason they have the driving log, in my understanding of the probationary system, is to get admissions from the defendant or the person that's on probation as to where he was, because they already have the GPS as to where he was. So they try and get admissions or solicit admissions if a defendant has violated the terms of his sex offender probation. So it became ministerial in that I don't believe they actually thought that he was visiting the school. There was a red light.
That's the condition, is it, visiting a school? That's what's in the probation report, and I think that was charged by the affidavit, visiting, and that's what the statute provides, if I recall correctly.
Yes, that is correct. But consider this a visit, and to appreciate the actual appearance of this strip mall, it just doesn't objectively appear to be a school, and there's no playgrounds or stopping guards or anything there. And the GPS failure to maintain the driving log, he had done it up to the bottom of the page. He's been brought around by his wife, it sounds like, on every errand in town. He had a 92-mile weekly trip he goes with her, and he's mid-70s. There's no evidence that he wanted to visit or intended to visit a parking lot with a school in a strip mall. And the driving log is just ministerial. It's to solicit admissions from the defendant.
Thank you. You're only at 12 and a half.
Okay, and then just overall, even Judge Porter, in his ruling on this revocation, basically said this just doesn't smell right. So those aren't the grounds for revoking a person's probation and sentencing him to 10 years.
That's just a colloquial expression, I'm sure, from Judge Porter.
Yes, and he's a great judge and very honorable, but
He's got a good
something
nose.
just not smelling right doesn't qualify really as a grounds for revocation of his probation. And basis of the probation is a deponent that's not there, and we already spoke about that, but I don't think it needs to reach the level of a 3850 against the public defender's office.
Well, I think one of the things, as Judge Vellante was pointing out, is the government cannot rely solely on hearsay to prove the violation. And so that test would apply to both charges. So the first one is, what evidence do they have that's not hearsay to prove a visit?
Well, they have his family that.
Does anyone show he's visiting, not near, not about? Visiting is the charge that is provided by statute 948.30.
Yes, there's no real evidence that he's visiting outside of the electronic evidence, which was not entered into evidence. But again, there's no one saying he was at the school or.
Conceitedly, if the statute, the condition was not to be on or about or near a school, that evidence may be by itself enough, but the legislature chose its word of art carefully for this additional condition of probation under 948.30 and said visiting.
Yeah, under that fact pattern, if visiting was, which this is not, you would be able to arrest any sex offender probationer for even driving past a school.
Well,
So there would
it
have to
makes
be-
some logical sense that the legislature would choose the word visiting so as to apply to situations such as this, that in order to prove willful violation, you just can't get a gotcha by going to a strip mall, a blacked out building, and you don't know that it's a school. You have to go the step further to try to visit that school.
And I think that's clearly not the case with Mr. Rodriguez. And I don't think anyone's just, I don't think credibility is even an issue. I don't think he's visiting the school. Then we have the driving log would be the second issue, but it's already substantiated by his GPS.
Yeah, we are left with the record that Judge Porter gave us. And if Judge Porter says he finds none of them credible, then the question remains, what evidence did the state adduce to prove this? And I say that having worked in the state attorney's office in the 20th Circuit before.
Yeah, I don't really see any evidence out of that he has an incomplete driving log.
Oh, that's a separate thing from this, but yes, thank you. You're correct.
Thank you, Your Honors.
You're only, well, you are at 15 now, so if you wish to reserve your time, we'll stop. I dropped my pen. I
Yes, Your
apologize
Honor,
for
I'm fine. Thank you,
leaving
Your
your
Honor.
screen.
Yes, I would reserve my time. Thank you, Your Honor. I'd pass the argument.
Thank you, counsel. We'll now hear from the Attorney General's office, please. Is it Benoit Knox?
Benoit Knox, yes, Your Honor. Good morning.
You might tell that I went to law school in New Orleans, right?
That's right. May it please the court, counsel. You already said my name for me. I represent the state of Florida in this matter. As to the hearsay issue, counsel himself did say that the fact that appellant was in that strip mall was not in dispute. Nobody disputed he was there. That is an issue that was not before the court. Whether he actually was there was pretty much conceded by the defense, because their argument wasn't he wasn't there. It was, yes, it was there, but it's not what you think it was. Therefore,
the statute says, and the probation that adopted or to adopt this statute said he must visit. So being present is not the same thing as visiting, if I understand the technical, the common understanding of the word visit. You have to do more than prove proximity. This is not like constructive possession. It's visit. So if there's only closeness or proximity in a car and no one shows evidence that he walked out onto the common area of the sidewalk, tried to gain entry, how do we show even an attempt to visit?
So I understand that concern, Your Honor. However, first, I'd like to say that that argument was never made below, what the definition of visiting is.
If that argument wasn't made below, and that's the crux of the issue, has Judge Vellante just mentioned, his point that he mentioned earlier about ineffective assistance on the face of the record? I mean, what's the strategic advantage of not making the most critical argument that might suggest that your client is not guilty of the violation? I'm having a hard time figuring that one out.
Well, Your Honor, I would say that part was not brief, so I'm not overly prepared to answer.
Well, let's
that.
go with let's go with something else.
Fair response.
Well, but let's go with something else as a sequel to what Judge Casanueva said, which obviously hit us in the face like a big pizza pie. You've got the situation where if someone is charged with a violation of law and the state doesn't prove it and they get a conviction, the facts don't support it, case law says you just can't do that. You can't get a conviction for a crime that didn't occur. So can you address that? That doesn't have to be preserved. That's by case law.
Fundamental.
Right. And I would say just as was discussed earlier, that the part that I understand the concern and I hear what you're saying, but at the very least, the state would say that the violation of the driving law was proved.
Well, okay, let's talk about that.
I have a question.
Okay.
About the preservation of the visiting issue. Didn't Mr. Garcia's counsel argue that it was a shared parking facility and he parked where there was an available space, and that doesn't mean he visited a school? Instead, he visited a shopping center?
I think that was argued, but what I don't
Is
believe.
that not
I think-
adequate? Is that not adequate to preserve the issue of the meaning of the term visit?
I don't, Your Honor. I don't believe that the specific definition of the word visit was discussed. I think what was discussed was what he did was not visit, but not whether.
But preservation doesn't require a chapter and verse identification of what is being objected to or debated. And he raised the issue of whether this was a visit. Would you not agree with that?
I think he raised the issue of whether what his behavior, what he argued that his actions were, was a visit, but I don't believe he raised the issue of what the definition of visit is. I don't believe he raised whether, because there was evidence with this 2 miles per hour. There was testimony from the probation officer that possibly he understood the 2 mile an hour movement of the GPS as he got out of this car and he walked.
Well, there was also, to that point, there was testimony that he could have been, I think there was conflicting evidence on whether he was attempting to go to a Botanica or to the barber shop or to the passport office. Any one of those could have been a visit, couldn't it?
So the evidence is that appellant actually never argued that he got out of the car. He did not argue that he went to Botanica. He argued that he stayed in the car. And why I remember that, I just want to say earlier, I believe it was Judge Delonte said that he wasn't driving, his wife was. That's not accurate. The testimony from the wife and son was that he was the one driving. So by that, we know he drove that day, and that's not present in his.
Well, if there was conflicting testimony about who drove, wasn't the trial judge in a position to resolve that?
I don't believe there was conflicting testimony about who drove. I believe everybody testified that he drove.
Let's have your opponent address that on his rebuttal, because that's consistently different with what he said earlier. I'm not sure that's going to make a difference in the outcome. Let me say I agree with Judge LeBrit that the visit issue seems to have been preserved, because I'm going to paraphrase what is in the record. And Garcia's counsel argued it was a shared parking facility. He parked where there was an available spot. That doesn't mean he visited a school. He visited a shopping center where a school happens to be that he did not know was there. That normally would be enough to pass the so-called sniff test on preservation, especially when there's some gaps in facts that the state wants to also argue wasn't preserved, then you could. And the trial judge was a big ally of the state in saying, I don't believe anybody here except the probation officers. But let's switch gears. I'll just be my only little question. Condition 16 and condition 32. Well, I think we've dealt with 32 pretty much. 16 seems to be a little bit of a different matter, but 16 seems to be an afterthought. And this happens a lot. You're very young. You may not have seen this pattern, but when the state charges a violation of probation, they go for the gusto first, the main violation, what really drives them. And then they throw in one or two little ones that, okay, we probably can win on this. We don't win on the big one. That seems to be what's happening here with condition 16 about the log. I mean, if I was a trial judge, the guy's got cognitive dislearning. That's even not in dispute. He's an elderly gentleman. He writes to the very bottom of the page, doesn't turn it over. Fuller didn't like that. Oh, turn it over. But there's no definitive time frame as to when he must turn in the driving log, or how far it has to be, when it has to be completed. He can use any form he wants. It's kind of loosey-goosey. So to me, that loses on the issue of substantial. We don't have to find that's also willful, because obviously he willfully wrote to the bottom of the page, but is that substantial, especially in the light that condition 32 is below weak? This case shouldn't have been charged. They should have waited for more information. They were hoping he'd show up and say, yep, I didn't, here's my log. I'm sorry you caught me. I was looking through the window with some infrared device and I saw a bunch of kids in there and really was, none of this happened. This is much ado about nothing, to quote Shakespeare. So that's my last question. I don't think 16 can survive unless 32 survived.
Well, respectfully, Your Honor, I disagree. I think that we're talking about a registered sexual offender who got probation. Probation is a matter of grace. He's asked to fill out a driving log. That's part of the things he is supposed to do. He doesn't do it. He doesn't do it for, I think it's 5 days. I think that's substantial. We know it's willful. He's asked to bring his driving log. He can't, everybody's talking about how he has diminished capacity.
So what's
but
your
he doesn't-
solution? What is your solution? If you're the appellate court, like Judge Kessler was asking your opponent, what's your solution? To remand to find out if the judge agrees this should be a violation standing alone, that was substantial and willful? Or is it apparent from the face of the record that we could make that call because the facts aren't going to change? Nothing's going to change unless people start lying on remand. And then we've wasted a lot of time doing nothing. What have we really done to move the ball forward except invite another appeal when they convict him theoretically? Oh, that's substantial. You didn't turn the page over. We got you. We're going to send you to jail for 10 years. Do we really want to buy another appeal on this?
Well, Your Honor, I believe that determination that it was substantial and willful was already made. So I don't really believe that if you remanded, it would be to make that determination. It would be to
Well,
determine.
No, I understand. You're entitled to your position. That's why you're the state. That's your prerogative. All right. Thank you.
And so, Your Honor, the state's position is that this was a willful and substantial violation. He doesn't have dementia enough to not report his driving up until the day before.
How do you know that? Wait.
Because I have it. Because he filled it out.
Okay. That's fine.
So he supposedly has cognitive issues, but he doesn't have those cognitive issues that month up until April 24th. He fills it out. And I would submit that all the explanations were given about the cognitive issue, about the language barrier, none of that makes sense. And the trial judge was correct in finding that that was willful and substantial because it's filled out in Spanish. He filled it out in Spanish the entire time, so he didn't need anybody's help to do that. Additionally, when looking at the log, we can see that he's just not taking that log seriously. On April 17, he travels 90 miles from 9 a.m. to 4:45 p.m. and he reports his destination as various. He just, he got to the bottom of the page. That doesn't mean he didn't understand to write on another page. We know he did because he filled out a driving log on a different piece of paper, a blank sheet of paper on another time. He just didn't care. He just didn't care enough to do the simple thing he was asked to do as a sexual offender. And the state believes that that is substantial, that was willful, and that he's not at liberty to disregard the conditions of his probation.
I have Ms. Benoit Knox. I have a question. What did the probation officer say about the supposed deficiencies in the log in the PO's affidavit? Were those the subject of any of the violations the PO identified in his affidavit?
No, the subject of the affidavit is those days that are missing, that he did tell the probation officer that they were missing, that we know that he was in that plaza because that's a conceded fact. But what I suggest to you is that you can take into consideration, and the judge could take into consideration those things I am arguing about the driving log in the determination that was willful and substantial. I'm by no means suggesting that those are the grounds for the violation. They're not. However, that log is in the record and the judge is absolutely free to look at it to determine how the appellant has been filling it out and how it's consistent with his intent, with his disregard for the rule of his probation.
Let me approach it from a different manner. I would like to explore again with you the nature of substantial on the log. It's clear that the trip to the parking lot where the Montessori school was, if I understand correct, was not on the log. Is that correct?
Correct.
All right. Now there's a gap of a number of days between entries. Is that also correct?
Correct.
Is there any evidence to suggest there was any driving done on any of those other days?
Yes,
From?
from appellant to his probation officer.
And he is the person who the judge said had no credibility.
No, the judge said his family testifying at the revocation hearing explained, giving a different story than the one he gave to his probation officer. Those people had no
Well, the
credibility.
purpose of impeachment, as I understand some of the case law, tends to prove that both statements are incorrect and unreliable. Is that right? Never mind. I will draw. That's pretty deep here. I'll leave that one alone. There's some case law suggests that when one impeaches, it basically says that neither statement is reliable, but that's not brief, that's not argued, and I'm not going to play quiz you on that one. So I would draw the question. Thank you.
If I may
My-
just say, I don't really believe it's a matter of impeachment here. I believe it's a matter of what he said when he's first called on the spot by his probation officer versus what his family says weeks later, months later, I'm not sure, when they're at a hearing.
Okay, got it. It's been a while since I read that transcript. I appreciate it. It's not like we don't read transcripts, it's that we read too many of them after a while.
I understand that. And if there are no further questions, the state would ask that this court affirm the revocation of probation.
Okay, any other questions? Looking at my video screen, I see nods of no. Thank you very much, counsel. We'll return to the appellant. You still have your 5 minutes remaining.
Thank you, Your Honors, and may it please the court again. And I may have misspoken. He may have admitted to driving to the Spanish-speaking probation officer to this strip mall. But what we're talking about is 3.5 minutes. I guess, is the driving log substantial, competent and substantial evidence of a violation of probation? And I would suggest it's there for admissions. They want these defendants to
Well, if
admit.
he's required to keep the log as a condition of his probation, and probation is grace, and there's 4 days that there's record evidence that he didn't do it, I think the trial court, and I'm saying I would or anybody, I think the trial court can draw an inference that 4 days is a bit willful. And the question remains, as Judge Vellante posed it, is this substantial enough to violate his probation?
Yes, so that is the question, I think, before the court. If his non-completion of the driving log ended, and it was actually, I believe, written in English, so he would have to get some assistance, but it does seem like he had established a way of filling out this driving log. And this is the driving log. He was called into the probation officers days later. It was not.
How many days later was he called into the probation officer? He was called the night and he was like to come in the next day?
No, it was, he was, yes, and he came in the next day. But it was 5 or
And
6
did the
days.
probation officer say, I can help you fill this out? I have a Spanish translator. Is there anything in our record that addresses whether he made a request for help or not?
The probation officer did request the assistance of a certified probation officer.
My question is, did the appellant make a request and to the probation officer says, I understand that I don't have it down there. Can you help me fill it out now? Did he make such a request?
He did not, and I would suggest that he should have filled out that driving log. He should have done it. Is it a substantial violation of his probation? There are other protections in place. And I think they were just bringing him in for an interview, and he had finished the page. He's a middle-aged or middle 70s gentleman that with diminished capacity, doesn't speak English, and I would suggest he doesn't even know why he's in jail right now. But the basis of the visit was that they alleged that he was visiting a school, and that was through the GPS monitoring system. It's only 3.5 minutes. They're monitoring him 24/7. They could easily send out a police officer if they feel there's a substantial violation and pick him up and stop his threat to the community or to any possibility of him seeing or viewing children.
And I'm sure that we can make the assumption that it's easy to send out a police officer at that time. We don't have a call record, and that's outside of our record. So if you stay there with the record with us, that would be helpful.
Yes, that is true, Your Honor, and I apologize.
It's okay.
He's in a parking lot.
It's not quite the same thing as a closing argument in the trial court.
Yes, he's in a parking lot. It's 3.5 minutes. He may have even, and you'll never find out from him because it was 5 days earlier and it's such a short period of time. his credibility as what he believed happened that day would be completely inaccurate, as most people's would at that point in time. But the only evidence we have is that he's in a parking lot, didn't complete the driving log, and he's serving a 10-year sentence, which basically would be tantamount to a life sentence for him. I don't think if your honors would reverse his revocation, I don't think he'll ever leave the house again. But I just don't feel like it rises to the level of a willful, competent, substantial evidence of and willful violation of his probation. I think it should be reversed. Or if your honors want him to have another hearing, I understand your honors worry that we're going to have another appeal.
I'm not worried. The odds are, whether or not I'll be on that panel with 16 of us.
Yes, your honors. So
That's not something that keeps me awake.
it wouldn't hurt anything to remand it and have another hearing on that issue as to the substantialness of filling out the driving log. And he would have no objection to that. I mean, what would it hurt? Thank you, Your Honor.
Thank you. Thank you both. Thank you for hanging with us on all the questions. We appreciate your candor and your preparedness very much. I thank you, and I will let you now exit. You're more than welcome to stay with us if you wish, or if you have more productive things to do, I understand.
All right, thank you, Your Honor.